Imagine a nation gets credible intel. An enemy is preparing to launch a devastating missile strike. Do they wait for it to happen or strike first to prevent catastrophe? Now ask yourself, is that legal? Welcome back to Due Process Daily, where legal clarity cuts through political noise. Today we're diving into one of the most hotly debated topics in international law: preemptive military strikes. Are they legal under international law, or just a convenient excuse for aggressive war? Let's start at the heart of the issue, the United Nations Charter. After the horrors of World War II, the international community came together and drafted the UN Charter in 1945. Its mission was to prevent war, not to justify it. Article 2.4 is where the rules begin. It says, and I quote, "All members shall refrain from the threat or use of force against the territorial integrity or political independence of any state." That's a blanket prohibition, but of course, there's an exception. Article 51 of the Charter states that nothing shall impair the inherent right of individual or collective self-defense if an armed attack occurs. So, right there, we have a legal dilemma. The Charter permits self-defense, but only if an armed attack occurs. What if the attack hasn't occurred yet, but you know it's coming? What if your survival depends on striking first? That's where the concept of preemptive self-defense, or what some call anticipatory self-defense, enters the scene. And this is where things get murky. The most widely cited case on this issue comes from the 19th century, the Caroline Affair. In 1837, British forces attacked an American steamboat named the Caroline, which they believed was helping Canadian rebels. And the U.S. protested, and the two countries went back and forth on legal justifications. Eventually, Secretary of State Daniel Webster articulated a principle that still echoes in legal debates today. He argued that self-defense must involve a necessity of self-defense. Instant, overwhelming, leaving no choice of means and no moment for deliberation. That standard, immediacy, necessity, and proportionality has become a cornerstone of the legal test for whether a preemptive strike can be justified. Fast forward to the modern era. Let's take the 1981 Israeli strike on Iraq's Osirak nuclear reactor. Israel claimed it was a defensive move to prevent Iraq from developing nuclear weapons. The world, not so convinced. The United Nations Security Council unanimously condemned the attack. Even the United States voted in favor of the condemnation. The Council's message was clear. You don't get to bomb another country just because you suspect they might become a threat one day. Now let's move to 2003, the US-led invasion of Iraq. The Bush administration didn't even pretend Iraq had launched an attack. Instead, it argued that Iraq posed a future threat, especially with alleged weapons of mass destruction. They called it a preemptive strike, but others saw it differently, as a violation of the UN Charter. No weapons of mass destruction were ever found, and the legal fallout still debated today. So where does international law actually draw the line? Under the prevailing interpretation of the UN Charter, preemptive strikes are generally not considered lawful unless they meet that very narrow Caroline test. That means the threat must be imminent, the response must be necessary, and the force used must be proportionate to the threat. But here's the issue. The term imminent is not well defined. How imminent is imminent? Does it mean hours, days? Can a country act based on satellite images, intelligence reports, diplomatic warnings? Legal scholars argue over this constantly. Some argue that in an age of hypersonic missiles, nuclear weapons, and cyber warfare, waiting for the first punch may be suicidal. Others worry that expanding the definition of imminence opens the floodgates to endless war under the guise of self-defense. The reality is this: preemptive strikes exist in a legal gray zone. Some countries, particularly powerful ones, assert broader rights to anticipatory self-defense than international law strictly allows. But unless the strike is reviewed and approved by the UN Security Council, it's generally viewed as illegal, especially when it's unilateral. You'll often hear terms like preventive war thrown around too, and that's a related but distinct concept. Preventive war goes even further than preemptive self-defense. It's not about stopping an imminent attack. It's about stopping a threat that may exist years down the line. That's even shakier ground. Preventive war has virtually no support in international law. It's generally seen as a naked act of aggression. And aggression, under international criminal law, is a crime. This was codified in the Rome Statute of the International Criminal Court, which defines the crime of aggression as the planning, preparation, initiation, or execution of an act of aggression by a leader of a state. That includes attacks that violate the Charter. So when world leaders talk about launching strikes to send a message or to eliminate a future threat, they may be opening themselves and their nations up to legal liability. Of course, realpolitik often overshadows legal analysis. Nations act in their strategic interest and then seek to justify those actions under whatever legal framework fits best. But make no mistake, legality and morality aren't always aligned. Now, there is one additional twist to consider: collective self-defense. If a nation is attacked, its allies can come to its defense under Article 51. That's why NATO exists. An attack on one is an attack on all. But that still requires an actual attack, not a future possibility, unless and until international law is updated to account for modern warfare realities, like cyber threats or asymmetrical attacks. Nations are left playing a dangerous game of legal justification. So, let's recap. Preemptive military strikes sit on shaky legal ground under international law. They may only be justified under the narrowest circumstances, where an attack is truly imminent and the need to respond is overwhelming and immediate. Preventive wars aimed at stopping future threats are generally flat out illegal, and yet in practice, nations often blur the lines. That's the challenge of enforcing international law. It's only as strong as the global community's willingness to uphold it. Thanks for watching Due Process Daily. If you found today's breakdown helpful, do me a favor, hit that like button, drop a comment with your thoughts on whether preemptive strikes can ever be justified, and subscribe for more legal deep dives that cut through the headlines and get straight to the law. Until next time, stay informed and stay critical.